Password.
No, serial number 1 appears for respond number 1, my lords.
Yes.
Appear for the petitioner in serial number 1.
Petition has become in purchase, my lords. Perhaps my friend will make a mention, my lords.
The review petition is not infructuous, Your Lordship. The students have...
Password. Hear you. Just read. Password.
Grateful.
Yes. Yes. No, now, if you say it is less than 1 crore, they are saying. No, you are saying in case of less than 1 crore, then it will be here. Otherwise, no. No, what is the limit you are saying? What is the for? If it is 1 crore 11 lakhs, what happens? No, so
in that part, I have taken a decision, but in that there was a mistake. Certain matters cannot immediately relate to the but in some cases, what renewable what has been observed is not there. Only by the sufficient what is there.
now the other side says it's less than 1.
Yes, I'll submit that. Whatever they are submitting, it's a matter of affidavit that extent is not very easy. What happens, but you also can that the total amount of the liability what was total income assessment was.
Now, where is the circular? Let us have a look at the circular.
It says here, less than 1 crore. Not being affected, not they are saying, no. Return will not get it. And let me come to the opposite stack. Asking to buy that.
Now let us first, you have a copy of the circular. Yes. So if it's less than the monetary limit, then no appeal would lie.
CEO company and the people department. What is this stuff? They only take the number of the 448. This is the lot of 450 on the CEO. That's how we find it. Okay, the other two is the fact. That application not as monetary. This also now, that also they have no revival. This is the complete corporation.
Then we'll call for that also and then decide on that. Which is that? ITA 448 of 20. Both arise as against the same order. Common order. So now the determination of whether it's above 1 crore or not must be made out from the impugned order, isn't it? That so we'll have a look at.
Also the important because in that you already felt the synopsis and base clause and all these things. After that, now they write this on road boarding, it's quite We are trying to give three times. Every time we give valuation and department has still not been out of control.
Third senior counsel appearing on behalf of the respondent in the ITA submits that IA 1 of 22, that for the purpose of disposal of IA 1 of 2022, records in ITA 448 of 2018 be called for. While making it clear that the said records are to be put up for the limited purpose of deciding the present application, that is IA 1 of 2022, registry is directed to obtain special orders and place the records before this bench. This is the matter. Matter is adjourned.
What are interrelated? So what are the law and both of them will go. Because my friend wants to club both the appeals and then calculate the tax liability, and also take into account what other factor which is not used to keep the count.
You can just file a memo for clubbing, assigning the reason. The Learned Counsel for the Revenue submits that the ITA 448 of 2018 will also is also in which similar application has been filed by the SSC, by the revenue, is required to be disposed of along with the present ITA and application filed in the present ITA. Memo to that effect is filed. Office to obtain special orders and list ITA 448 of 2018 along with the present matter. We share it with you.
Not serial number 3 appears for the petitioner.
Appear for the second respondent, Your Lordship.
Not pending consideration of this application, my lords. The National Commission for Indian System of Medicine has already considered, my lords, the directions of this court and has passed the order on 27/4/2022. Therefore, my lords, this application may not survive for consideration, my lords.
Decided on
27/4/2022, my lords.
by the NCISM.
By National Commission,
Yes,
my lord, NCISM.
Yes, Your Lordship.
It is submitted that pursuant to the order dated 29th June 2021. The NCISM has already disposed of the matter on 27/4/2022. Accordingly, the prayer sought for in the IA has been rendered infructuous and not necessary. Accordingly, IA is dismissed, taking note of the submission of counsel for the petition.
One submission, Your Lordship. This matter is in fact related to serial number 1, the review petition. The review petition, the only point that survives is that particular finding that students could be admitted even before permission was granted or denied. And in respect of that, the Honorable Supreme Court's judgment, which was awaited on the previous occasion, has now specifically considered the scheme. And in view of the judgment passed by the Supreme Court, even the review petition may be disposed of. Although there is no specific word that is stated by the Supreme Court in its judgment, the scheme itself has been captured in toto. So nothing much would survive if the matter is disposed of in light of the Supreme Court's judgment.
We can't dispose of the matter. Now, insofar as the prayer in the review petition is concerned, you are not aggrieved by the final result. But we will,
Yes,
but you are aggrieved by certain observations made. Now, what we can always clarify is that there is no occasion for you to challenge findings recorded in the order in light of the final relief that has been granted. And accordingly, the findings, the correctness or otherwise of the findings is kept open. Then you can take
Yes,
the
Your
benefit
of the Supreme Court's judgment. Yes, Your Lordship, that would suffice.
that is kept open for you, so that you can rely on whatever the law is, and this order will not come in the way of you contending
Yes, Your
otherwise.
Lordship.
Milords,
Yes, Your Lordship.
may I submit, Milords? Milords, may I submit, Milords?
Now, 1 minute,
Please,
just 1 minute.
please, Milords. Milords, may I submit, Milords? The NCISM, Milords, now has independently considered the matter and has passed the order granting permission for this is pertaining to the academic year 2018-19. Therefore, Milord,
No, you are really now we are not interfering with the final order.
yes, Milords.
They are only aggrieved by certain observation made, but in light of the final order passed, they have no occasion to challenge the order. So
Milords,
they are
even
only going to clarify.
Milords, because Milord, the matter is remanded and they have considered matter afresh. Even Milords, now Milords, if any order that would be passed, Milords, they will unnecessarily will disturb because the students pertaining to academic year 18-19.
No, they will not be disturbed, Your Lordship.
That has nothing to do with the present matter. They're only apprehensive that some observations may be taken benefit of in other proceedings.
Other cases. Lordship may clarify with Milords that this will not disturb the present case.
The review petitioner have sought for review of the order on the limited ground as regards to observations made in the order dated 29 June 2021 while disposing of the writ petition as is detailed in the review petition. Is in the context of observations made in the order in the writ petition being made use of in other proceedings. With the said observations, in light of the submission that the apex court has clarified the legal position, matter is disposed of. No, so we have clarified
Yes, Your Lordship.
that there was no occasion for you to challenge the observation in light of the final result. So the findings will not operate as res judicata.
Grateful, Your Lordship. That would. I'm sorry, the internet connection got disconnected and the court was, the video had disconnected.
You have copy income. Okay.
So fresh matters will come up. The fresh matter. Tuesday. Now give it, it'll come. Just file a memo for being spoken to. You file a memo, we'll have it tomorrow and we'll. We'll have it at 2:30. We'll get the file now. Just intimate the other side that will be called. No, the why the mistake crept in was earlier that's why the mistake may have. Yes. No, my early as soon as the file comes, ask him to be there, but let him inform the others. Yes.
The Lordship, kind leave, my Lord.
Yes.
Serial
Page number
number
1, 1 to 6. Page number 2, 7 to 11. Page number 3, 12 to 17.
Yes. You appear for? Have you informed the other side? You must inform in advance in my court. When it's called, I'll make a note of it. When it's called, I'll accommodate. Otherwise, inform the other side and report to the court office.
Page number 4, 18 and 19. Page number 5, 20 to 27.
serial number 20.
Just 1 minute. So which matter? Serial number? You want adjournment, is it? Have you informed the other side? Inform and report to the court office.
Page number 6, 28 to 33.
Serial number 32, my Lord.
Yes.
32, my Lord.
Yes.
I pray 2 weeks time, my Lord. I inform the other side. Paisha Legde.
At a request made on behalf of R2, list the matter after 2 weeks.
36 also, my Lord. I have informed both, my Lord.
Page number 7, 34 to 39.
36, same order.
Yes.
Yes. Now we have passed some interim order, is it? So we'll continue. The same. Let us see. Coding file. Earlier direction not to take precipitative action pursuant to the impugned order to be continued till the next date. List the matter on 7th. 13. 13. ಎರಡು matters ಅಲ್ಲ ಅದೇ ಆಗ Have you informed the others? List the matter after 2 weeks at request of the respondent. Respondent's counsel who submits statement of objections will be filed by the next date. Yes. So when do you want it? When do you want it? Relist the matter in the same stage. The mailable on top of the list on 6th.
Page number 8, 40 and 41. Fresh matter, page number 1, Kumar Joshi.
We'll call it along with that other petition. Let us see. The HCGP accept notice for respondent 1 and 2. Emergent notice to respondent number 5. Then Counsel Venkatesh Arbati is directed to accept notice for respondent 3 and 4. List the matter along with the WP 25359 of 2017. So let us see when that matter comes. So that let us see, let that record come. We'll fix a date, and then if it is so, we'll see what is to be done. Consideration of interim prayer is kept open. List the matter on 7th. Take out notice. Then HCGP accepts notice for respondent 1 and 2. Emergent notice to respondent 3 and 4. Petitioner is permitted to take out notice by way of hand summons to the said respondent. No, so yesterday I said that till appointment of regular employee. Huh? No, we don't know. We don't know. Now that must be stated by Christ, isn't it? No, not to relieve till appointment of regular employee. That will. Put it. So that now now you file may take your stand in some of the matters. So correct. So we are saying till a regular employee is appointed because
regular employees are also appointed. There are still 2,130.
no, that we'll see. So then, if something happens, then I'll reserve you liberty to come again. I'll grant you interim relief, subject to that condition. If such threat comes, then I'll reserve you liberty to come back. So the reason is, now suppose in some weightage is given and you participate in the recruitment process. Despite the weightage, if you are not selected, then there is a problem. There's a difficulty. It is submitted. Now you take your stand in 1 or 2 matters comprehensively along with the Christ, and then we can consider. Otherwise, matters will keep coming until there is some resolution of the legal controversy. The petitioner submits that an interim order is passed in identical factual matrix in other matters as well, including in WP 5359 of 2022. Accordingly, there would be an interim directing the respondents not to relieve the petitioners from the post held by them till the next date of hearing. The interim order would be in force subject to the further condition that petitioner the interim order would be in force subject to the condition that the petitioner the same would be in force till action is taken by the respondent to fill the post by a regular appointment. Further interim relief. Liberty to claim further interim relief is reserved to the petitioner at an appropriate stage. AG accepts notice for respondent 1 and 2. General Counsel Nagaya is directed to accept notice for the third. Take out notice. AG accepts notice for respondent 1. Is there any standing counsel for Bangalore Zilla Panchayat? MS Devraj. MS Devraj. General Counsel MS Devraj is directed to accept notice for the third respondent. Second respondent? Second respondent Chitradurga Zilla Panchayat. The Mahesh Davangere. Chitradurga. Praveen. General Counsel Praveen is directed to accept notice for the second respondent. Let us see, you serve, let them, and then you move the matter after you have served them, you move, we'll fix it. What is there? What is that? Now there is already another writ petition pending, whereby the transfer of these employees has been challenged, and there is an interim order in that matter. Now that matter is pending since. So now you have to move for a disposal of those matters. Now in the same ground he has urged in the present matter also. So then because of that stay here also we have to give a stay. No, correct. But in case of this, your daily wage or contract? Yeah, contract basis, and they're getting how much? 14,000 salary. So for daily wage contractual, transfer is a question that will have to be examined. If you're a regular employee, you can transfer. For daily wage and unless the office itself shifts. Otherwise, since the service conditions are not fixed, transfer is doubtful. We'll grant an interim order and list it along with that matter. You get ready on the main matter and move that matter. Which is the other one, writ petition? 58330 of 2017. All these three are relating to the same. Or same department. Petitioner submit that they are contractual employees, and in light of the nature of their employment and selection, question of transferring them does not arise. Reliance is placed on the interim orders passed as regards employees of the same respondent in WP 58330-383 of 2017, comma 9883 of 2021, and 11725 of 2021. In light of the said submission, there would be an interim order restraining interim order of the impugned order at annexure C till the next date. List the matter along with the mail on 13th. By then you take your stand on 13th. I stayed till the next day. EGA is directed to accept the FTGP is directed to accept notice. For Sports Authority also they only for respondents 1 to 3. No, but that Sports Authority is autonomous. Isn't it? Huh? Emergent notice to respondent 2 and 3. HCGP accepts notice for the first respondent. Petitioner is at liberty to take out notice by way of hand summons to respondent 2 and 3.
Lord, I appeal for the petitioner,
My lord, I am appealing for respondents, my lord.
If my learned friend is ready, my lord, I would address argument. This is a matter pertaining to the suspension. The petitioner is questioning the legality and the validity of the order dated, my lord, 17 February 2022.
I already initiated departmental inquiry, my lord. It's going on. Within 1 month or 1.5 months, it is going to close, my lord. Already departmental inquiry has been initiated, my lord. And
Lord, initiation of the departmental inquiry will not preclude from revoking the suspension order if the charges are serious in nature. My lord, where the petitioners has acted like unbecoming of a government servant, then, my lord, I can understand. On a flimsy ground, could your lordships kindly see the, my lord, the regulations or the order suspension reveals that Annexure C may be kindly seen, my lord. In page 31. Page 31, my lord. The allegation is very simple in nature. May I read, my lord?
Yes.
You are working as a first division assistant in the office of the Karnataka State Pollution Control Board, Bangalore. You are entrusted with the administrative work in the administrative branch of the office to look into the recruitment division and the technical officer for file. As per the government order number so and so, it is incumbent upon the department concerned to pay in charge allowance to those officers who are working on OD bar deputation. Further, as per the reminder dated 6/4/2021, issued by the government of Karnataka, it is made very clear that if any of the officer deputed on OD or deputation is to be continued for more than 6 months, the approval of the government of Karnataka is mandatory. While discharging,
Just 1 minute. Just 1 minute. Now, the respondent, the only allegation that is made out he has left out certain names.
One person's
that,
name he has left out. Lord,
no,
you are
afterwards
asking
they
for
say,
an argument's sake.
Other
If I have been left
no,
out,
just
my lord,
one. So now the only allegation is names of certain employees who had come on deputation has been left out.
please, my lord.
Now, the fact that the inquiry is already started, now what more will be the apprehension by these people coming back? Now, finally, departmental inquiry will be decided on its merits. Suspension cannot be used as a punishment. Now, he will let him come back and then let the inquiry go ahead. Whatever evidence is gathered for the purpose of your inquiry, you already have it in your hands. So what is the necessity for continuance of the order of suspension?
My lord, he was working in administrative branch, and he was handling the administrative work in the administrative branch. My lord, he has omitted to mention the name of Putraju, and after he was kept under suspension, the other officers, names of the other officers who are working on OD have also been left out by him in the note sheets. And my lord, just I will draw your lordship kind attention to the conduct of the petitioner. My lord, he has submitted the requisition on 13/1/2022. On the very day, my lord, he has approached this honorable court in WP number. He has filed the writ petition before this honorable court in WP 723/2022, alleging that with a prayer to set aside the suspension order. The day on which he submitted the requisition, on the very day he has filed the writ petition. This honorable court, considering all these aspects, was pleased to direct me to consider his representation. And I have considered representation, and I have given the regional endorsement, which is marked Annex C. And the reason why I have kept him under suspension, he was handling the administrative branch. And not only the name of Putraj was left out, my lord, the other officers who are working on OD, their names have also been omitted by him. That is a clear dereliction of duty on his part. Considering all these aspects, he was kept on suspension, and now, as per the orders of this court bench of this honorable court, wide annexure C, my lord, E, my lord, I have given a reasoned endorsement as per annexure C. Now, departmental inquiry is going on. My submission is that it is a premature stage. Within 1 or 1.5 months, inquiry is going to be completed, because my lord, only the name of Putraj was not left out, my lord. I have just will draw your lordship kind attention to para number 53 of my statement of objections. Para number 53 of my statement of objections, my lord.
Suspension cannot amount to employment.
My lord, there is a clear dereliction of duty. He has committed misconduct.
Correct. That will impose punishment in the department inquiry.
My lord, now the
What is the
departmental
purpose
inquiry is
of
going
paying him? Why should you pay him subsistence?
I have already submitted my.
No, please unmute. We can't hear you. Please unmute.
I'm sorry, my lord. You
Ah,
should have
I'm
been
sorry.
posted in some other place.
My lord, only the
Instead
name
of
of
the place where he was getting suspension.
only the name of Putraj was
Ultimately,
not
exchequer is money, my lord. A person is simply sitting and getting in a subsistence allowance. It causing a loss to the exchequers. Let them extract the work.
my lord.
It is not
Now you are
Draw your
you
lordship
can consider posting him in any other office.
Please,
My
my
lord,
lord.
I draw your lordship kind attention to para number 53 of my statement of objections, my lord. Your
One
lordship may
minute,
kindly have a
one
look on it.
minute. They
I have
have
mentioned
enough
para number
provision.
53, my lord. I mentioned the names of the other officers also who are
Lord,
working.
they have invoked the provisions which has been repealed. That I have invoked the conduct rules of 1966, which has been repealed in the year 2021.
My lord,
If they commit a mistake, no penalty for them. If there is some, my lord, after I proposals, my lord, the section officer will have to scrutiny. Thereafter, the assistant administrative officer, then the administrative officer, then the chairman. None of these persons whom the files has been processed or passed through have been made accountable, except me. Even assuming if I have committed a dereliction of duty, what prevented the section officer to verify and say, no, you have omitted this person? Being a only man in the administrative section, I have been subjected to, my lord, this kind of an exploitation. In the suspension order, kindly see, my lord, the endorsement which they have stated. You have left out ink page 32, my lord.
Now, what is
Only
the
put
purpose
track.
of continuing them in suspension by paying subsistence allowance? Why should you pay subsistence allowance? Get work from them by posting them in any other office.
My lord, my submission is that, my lord, exercising, my lord, what my learned friend has submitted that it has not been processed through higher ups, that is incorrect submission, because the file was processed through MS and chairman, my lord, through respondents, and considering all the facts, they have given a well-reasoned endorsement to his representation. That has been marked as Annex C, my lord. Annex C, page number, my lord, 31. And my lord, invoking regulation 34B of the Karnataka State Pollution Control Board cadre recruitment and conditions of service regulations 1992, I have exercised my powers, my lord. And now inquiry is going on, my lord. So it is a premature stage, and my lord, the process of keeping him under suspension has been well followed as per the rules and regulations, my lord.
No, there must be some purpose of suspending him. Now you can't treat it as a punishment. Punishment is to be at the conclusion of the inquiry. Now, after 6 months, if you are going to pay him subsistence allowance, then that itself is a loss to your exchequer. Put him in some other office, get work done. Impose your punishment, finish your inquiry fast. There's no purpose of keeping him away. And you can't treat this as a punishment. The petitioner has called in question the order of suspension at Annex A, as well as the order at Annex B dated 12/1/2022. The facts as laid out are that the petitioner was placed on suspension for an alleged misconduct on 11/1/2022 and was again placed under suspension by order dated 12/1/2022 in terms of Rule 10(1)D of the KCS CCA Rules 1957. Also, it is submitted that petitioner sought for cancellation of order of suspension and subsequently had approached this court in WP 723 of 2022, which came to be disposed of to consider the representation of the petitioner. Next, it is submitted that by a detailed order, which is called in question in the present matter, in the suspension continued. Next, the counsel for the petitioner would submit that departmental proceedings have been initiated and it was found out that there was a dereliction of duty on behalf of the petitioner insofar as information as to officers who were working on OOD/deputation was not correctly furnished as name of one Dr. Puttaraju HR. OD/deputation was left out. Full stop. It is further submitted that upon a detailed examination, it is found out that the subsequently that three other employees by name Srimati Umme Hamida, Adam Saab M. Patel, and Baswaraj Mamadapura have also been left out from the list of those working on OOD/deputation in the office. Accordingly, it is submitted that there is a grave misconduct that has been committed. A learned counsel for the respondent submits that the legal requirement to pay subsistence allowance after a period of 6 months, is it?
Yes, my lord.
After a period of 6 months would result in a loss to the exchequer and keeping suspended employees out of employment unless strong case is made out is also not to be encouraged. Also, he submitted that apprehension regarding interference in the departmental proceedings can be appropriately addressed if the employer is of the opinion that the delinquent employee should not be kept in the same office by posting him elsewhere. Good stuff. Next, heard both sides. It is not in dispute that the order of suspension having been passed in January, 6 months time has lapsed. No doubt departmental proceedings have been initiated. However, the question is as to whether the continuance of the employee under suspension at this stage is required. If it is the case that departmental inquiry has been initiated and a lapse preliminary, and there has been a preliminary perusal of all records to find out the lapses of the petitioner, as is evident from the endorsement at Annexure C. Any further apprehension of interference by the petitioner in the departmental inquiry proceedings could be addressed by posting him in an appropriate place. However, this is an aspect to be considered by the employer. Next, suffice it to state that the employer is to reconsider after lapse of substantial time as to whether case is made out for suspension. Having noticed that order at Annexure C has been passed on 17 February 2022 and the reasons assigned, all that could be stated is that the application of mind, all that could be stated is though the employer has considered and stated that there has been lapse of on the part of the petitioner as regards furnishing list of those employees on OOD. However, that by itself would not be a germane consideration for continuance of the order of suspension even after the period of 6 months. Accordingly, we hold that there must be sufficient application of mind as regards to the necessity of continuance of the order of suspension after lapse of 6 months. Payment of a subsistence allowance, even to the suspended employee, would also result in loss to the exchequer, and it would be in public interest to ensure that the suspended employee services are made use of while addressing apprehension of the employee working in the same office appropriately, if required, by posting him in another office. Accordingly, the order of suspension is that the reconsideration of the order of suspension at Annexure C is set aside, as also the order of suspension at Annexure A and B. It is up to the employer to
B also, my lord.
take
Annexure A and B. Sorry to interrupt.
these appropriate steps to ensure the non-interference by the petitioner in the departmental proceedings. Yes.
Public.
Who is the answering respondent? Yeah? This is the matter in B group, week after next. In the week commencing from 18th of July, office objections raised on the reply filed by R2 to be complied with by the next day.
Serial number 8. Hari Krishna is Sola, serial number 8.
Each time granted to do the needful. Same order. Yes. This is the matter in B group, week after next. Yes. Week's time granted for necessary compliance. Week's time granted to take necessary steps as regards issuance of notice to the unserved respondents, as also for filing of court fee. Who is the answering respondent? Who is the answering? Who is the contestant? One hand, AGA, CGP accepts notice for respondent 1 and 4. What about 2? Who is the standing counsel, KPSC? Yes. Prakash? Learned counsel M. Prakash, director, accept notice for the second respondent. Nagaya for the third respondent. What about fifth respondent? Emergent notice to the fifth respondent. Emergent notice to 5 and 6. Now, what is the relief you are seeking? By whom? No, correct. That's how you can prevent. No, correct. I'm asking you, suppose an ad hoc employee is replaced by the regular recruitment process. Then what is the security you can ask for your tenure?
That's why the main belief is in respect of either absorption into permanent post or into service weightage to even these non-teaching staff. But identical belief has been granted in the main petition.
You are working as
There's non-teaching staff and six petitioners, three of them are nursing staff, who are secretary assistants and comes personal assistants. All are non-teaching staff. What's happening is when the call for appointing permanent weightage is not given to these non-teaching staff. On that ground, this petition is for.
no, then correct. That has to the recruitment process rules will have to be amended. Since how long you have been working?
I just page number 12.
No, but what is your right now to continue?
Right that I also have a right to apply and be evaluated in the same manner as teaching staff are also going to be evaluated. That's kind of challenge the recruitment process. I have been serving between 2017 and 19 these appointments. I have substantial work experience. This whole ground that I am a non-teaching staff, the same evaluation criteria are not applied to me.
No, now you participate in that recruitment process.
That have participated with the provisional list is not a given published. There is a unit writer, somebody else is appointed in my case, I will be left without revenue. The question is before in the main petition also 8/4/20, it is an identity of
No, I will only observe. You will not be that this interim order will be enforced till regular appointment is made. At that point of time, you can reapproach the court in the same matter seeking for further relief. That's how it is. Now, for 2 years you have worked. Now, what weightage they'll give? If they have to give a weightage, that's a policy decision to be taken by them. Now, in the regular process, you participate until it is amended. Now, that question would be premature to be considered now.
I will see what we are saying, but if this is only in the next appointment or the appointment of a permanent post, then I will certainly be displaced.
But you can't help.
I will give attention to the order of identity matters which is in the next day.
No, correct. No, we are aware in other matters also. But I'm saying regular appointment, you can't stall it.
Because I'm not saying that regular appointments need to be stalled because only that these petitioners are not
Everybody, correct. Everybody are coming on the same ground, including in that residential schools, etc.
That's why I understand this coming up this week. To be back at that, and that question is because over there the protection is the next day. Here it is only till the appointment.
No, but the giving of weightage is left to the government. How you can force them to give weightage?
The unfairness is this because the service that weightage is not given to these non-teaching staff.
There are two different classes, teaching and non-teaching.
So I'm not seeking the appointment to teaching, being a person of the non-teaching staff. That is
Correct. That's why only for teaching they have given weightage, not for the non-teaching.
Humble submission is that intelligent differential is not there as to why.
That itself is a classification, teaching and non-teaching.
But for the purpose permanence of the post, it is that it is not a level playing ground is my submission. So this argument
What are you working as? What are you working as?
Three of us are as nursing staff and the remaining are first or second division. All not teaching staff. All members of each section who do this also livelihood. And there is that livelihood of appointment of permanent post. So they can be displaced. Be left without all I'm thinking is their opportunity to participate, just like the others are also participating. I'm not saying that those posts should not be filled in. I am in that post as a waiver. I have been carrying out duties to the best of my ability. Now, for an unfair criteria evaluation.
No, yours is a backdoor entry, isn't it? Yours is a backdoor entry.
If they are contract employees, most while R5 and R6 schools, R3 schools, if it is not exactly a fact of the law, it is on temporary basis. It's that we have not been made permanent. Otherwise, there is no other compromise that is sought in respect to appointment or being made permanent. What we see that in the respondents
that I've seen, but I'm saying yeah, we get scared in the service matters. In one you do, 10,000 people will come saying your lordship has passed an order in that matter. Please extend parity. No, correct. But what I'm saying, let us see. But I'm saying you work for 2 years and now you are saying, no, you give me weightage. How is that? You say,
I'm not saying that without any evaluation or without any other selection process, we be permanent. I'm saying that I participated in the process and I have participated. I said so, even the petition that is
so now that process is already completed.
yes, but provisional list is not published.
So correct. So now at this stage, how we can intervene in the process and ask them to give you weightage?
I will only be given the same protection that several others in my similar situated case of position have been given.
Wrongly.
No,
The petitioner to seek for an interim protection not to be relieved till the next date and rely on interim orders passed in identical factual metrics in WP 50320 of 2019. Taking note of the same 50320 and 8442 of 2020. So that is reserved, is it, the main matter? It is further submitted that in the connected matters have been heard and reserved for orders. Subject to further consideration, there would be an interim order directing the respondent not to relieve the petitioner till the next date. Needless to state, the orders passed would be subject to final orders to be passed in WP 8442 of 2020. Glad yes. It's the matter on 14.
I appear for the respondent.
What about the executive officer, Taluk Panchayat, Kolar?
Yes, I'll file the wakalat.
And Jilla Panchayat, Kolar also you will accept?
ಹೌದು ಹಾಕಿದ್ದೀನಿ ಒಂದು ಹಾಕಿದ್ದೀನಿ ಅದು ಪ್ರೆಸಿಡೆಂಟ್ ಹಾಕ್ತೀನಿ ಪರವಾಗಿಲ್ಲ. Some time is given.
The learned counsel PJ Somyaji undertakes to appear for respondent 2 and 4 as well. List the matter week after next.
ಅಲ್ಲ 22 ಮ್ಯಾಟರ್ ವೀಕ್ ಆಫ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬೇಕಾದ್ರೆ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಲಿಲ್ಲ 22 ಮ್ಯಾಟರ್.
List the matter in the week commencing from 18th of July. Okay.
Number 15.
I appeal for petitioner notes. I filed an application for amendment notes.
During the pendency of the case, my lords, another provisional list is published by the respondent one medical college, my lords. And therefore seeking to challenge that list, my lords.
We'll allow this application for amendment. IA 3 of 22 has been filed. Seeking for an amendment as regards the pleading in light of the subsequent events. Isn't it?
Yes, my lords. During the pendency, another provisional list has been published.
Now, if your challenge is only to a provisional list, we'll ask them to consider your objections.
Please, my lords, let them do that. Because, my lords, the last date to consider the objections was on 23rd 6th. That date is over, my lords, now. Now, anytime they may publish the final list also, my lord, but till today they've not published that. Therefore, my lords, I'm seeking to amend based on this.
Correct. Now we'll ask them to consider yours.
Please, my lords.
What do you think?
A time limit to be fixed, my
Sure.
lords, since any minute they're expected to
Yes.
publish the final list.
Yes, now you appear for respondent number. So who is the answering respondent? Respondent number 1 is it?
Respondent number 1 is a college, my lords, medical college. The direction is to be issued to them, my lords. Page number 3, my lords, is the cost item.
Now the list is published by whom?
Respondent number
By
1.
the first respondent.
Please.
Then you consider it. Will no, correct. Now their only challenge is to the provisional selection list. Now during the pendency of the writ petition, one more provisional selection list has been published. Now they have already filed. You have already filed your objection to that.
Yes, my lords. I have attached that to my application, lords, amendment application.
So they have filed their objection to that provisional seniority list. You consider it before you publish the final seniority list. That's all.
Lords, my instructions are, my lord, that today itself they may pass the final list. So in that case, my lords, I will want this writ petition to be on the board, my lords, because that will enable me to challenge the final list in case they pass it today, my lords. Let them consider this, my lords, but let the writ petition be on the board, my lords.
No, then otherwise you will keep it alive.
Please.
You find out. We'll have it on Tuesday. You find out if they say for some reason that there's a delay, then you would undertake to consider, then we'll dispose it up and let her file a new petition with new fees, new client.
I just spoke to my client this morning, my lords. You said in fact today it's going to be published.
What? No, correct. What happens?
Yes.
Now it will result in clogging, isn't it? Now that will give you a separate cause of action in case. Now let us see. We'll have it on Tuesday. We'll have it on Tuesday.
Please. But and so far as office subjects are concerned, my lords, there seems to be some error, my lords. They say second set. There's no second set here. They need to be overruled, my lords, office objections.
The amendment application filed seeking amendment of pleadings in light of subsequent events is allowed, taking note of the amendments in the application. Amended petition to be filed. This is the matter on 6th.
Its office subject may be overruled, my lords. They say a second set to be filed. English translated copies to be furnished in both sets of WP. And the second office submission also may not relate to this present petition.
The generation office subject. better copies of annexure E and H. Where counsel for the petitioner undertakes that better copies of annexure E and E1 would be published at the time of hearing of the matter.
Wait,
That is the only office objection. Accordingly,
Please.
office objection is overruled.
wait.
Taking note of the said undertaking.
On
Yes,
Tuesday, on Tuesday.
yes, 6,
May I request on 7th, my lords?
7. Yes. Then shall we relist it on 6th? 6th. Relist the matter on 6th. One after the other. Huh? No, there's nothing wrong. What is that? It's a legal practice, isn't it? So there's absolutely nothing wrong. What is that? Page? No, that is a what? No, what is there? What is wrong? The counsel for the petitioner submits that an identical factual matrix in WP 9460 of 2022. Interim order has been granted. Accordingly, taking note of the same, respondents are directed not to release the petitioner from service till further orders. This the matter along with WP 9460 of 2022 and connected matters. AGA is directed to accept notice for the respondents. When is that other set? 7. They are pleading, they have filed their objections, is it?
One matter they have filed, EDC has been notified in the other matter. The last petition they instructed, they will make out. Their objections can ready, not taken.
This is the matter on 7. No, what is there? So when I was also practicing, I was a lawyer for all this road widening matters. So if one person comes in the road, we file one writ, then another 50 people will come. There's nothing. Let us see. Office objection to the complaint. Now, who appears for the respondent? Who is the counsel? No? No, correct. There is no counsel shown in the cause list as representing them. No, correct, but they will have to be served, isn't it? Now, who is the answering respondent? So then you take out notice by, it's after all in Bangalore. I will permit you to take out notice by way of hand summons. You take, then we'll fix a date. If they come, it will be easier to dispose the matter. Yes, petitioner is permitted to take out the notice afresh as regards respondent 2 and 3. Petitioners are permitted to take out notice apart from, is also is permitted to take out notice by way of hand summons. AGA accepts notice for respondent 1 and 4. Relist the matter in the same stage in the week commencing from 18th. By then you pay the process and take hand summons. You serve it, let us see. Media comes within this jurisdiction or what? How? Not. So who appears for the respondent? No, we'll pass over. If she's there, we bring her. We'll pass over. Let us. Relist the matter on 6th. You just tell her to get ready. Let us see now. All the old matters are also. Let us. Then we'll have it in B group. They file their objection, isn't it? Let us. A request petitioner list the matter week after next. Yes. List the matter on 7th at request of the petitioner.
My lord, incorrect submission before the Ghana report is ordered in March. Under similar circumstances, petition number 8664 of 2022.
Order dated?
Order dated 22nd April 2022.
Read the full order. Read the full order of 22nd April.
22nd April 2022. That is order. Interim order passed by this honorable court.
Yes.
Under similar circumstances, petition number 8664 of 2022, this court noticed a similar clearance and directed that until the recruitment process is initiated by the respondents to appoint the personnel in accordance with the law, the service of the petitioner shall not be discontinued. It is very much clear that the notice inviting the tenders issued on 8/3/2022 is contrary to the regularization of the respondent bank. The bank is precluded from taking the service of one set of temporary employees and replace them with other set of temporary employees. Such action will be contrary to the law. The honorable court also. This matter came up before the honorable court last week. Last week, this honorable court here dismissed my lord. Those people are working as a daily wages, not the panel. And as for the policy petition, they informed all the branches who are not in the panel to remove them. These people were removed the branch. And they came to this before court, and this honorable court has passed order. Till the recruitment process is completed, let them continue. Regarding that outsourcing and all, this honorable said they are back to the court. And that matter is over. But in this case, my lord, this different case, there is no similarity. In this case, this person was Respondent principal was working as a daily wager on part-time basis in a branch. One day, one customer came and he gave him one requisition slip. It was him to hand over to the concerned officer. This requisition slip kept for 2 days. And after 2 days, he cancelled that name of the person and put some other name, one Kumar's name. Actually, that this is the company's. Then that he has handed over to some process. Also, I do not know part of that. I do not know. Those people they encashed. The check was issued in the name of Kumar. They used the check leaf and encashed 5 lakh rupees from the bank fraudulently. And when the bank came to know this fraudulent like all this, then the bank initiated action against this person by issuing charge sheet. Even though he is not employed, in order to give principal justice, the charge sheet was issued. Inquiry was conducted. He was found guilty, and punishment is he has to be penalized from the bank. And this person, this respondent, immediately he made this 3% 5 lakh rupees to the bank, and he has admitted the fraudulent act. Now, my lord, after this, my lord, now this after this person has now in this case, my lord, then he has filed a petition. In this repetition, my lord, you can't not spend ideas in the prayer in the repetition.
He has not stated regarding the earlier incidents.
No, nothing is there because I do not know, my lord, either by order is order, the code as marking order. This order is same order, production of that order. This order is passed in 8664 of 22. This same order has been reproduced by just changing the cost attribution of that person. This here, and my lord, then this entire amount has also been reimbursed now. And my now lord, this another he filed the repetition. Now your lord, prayer, my lord, prayer is to pass the order issued by the bank, will depenalize him. There is nothing is there is no prayer. On this basis, this is not right, my lord. And more than that, now petitioner has sent a letter to the managing director. You do not implement this order, I will file a contempt petition against you.
They have not mentioned anything about.
Nothing, my lord, there is nothing. And just the reproduction of that earlier order. And where is this innovating tender and all comes here? Here this person has been actually was dismissed here because there is no provision for dismissal. He was a TM panel. That's all. Where is 44, my lord? Here. Where is 44? Page number 44 is the repetition. And I have also filed the detailed application statement also. 44.
It appears the order is by mistake. No, there is no question of outsourcing. Read the interim order. That is a mistake. You look at the order. Order code. Order code. No, you read the order. There is. No, then it has nothing to do with the facts of your case. No, look at the interim order. No, look at the interim order. It has nothing to do with your case. Does it have anything to do with your case? And then that we'll consider separately. I'll recall this order, we'll consider it separately. We'll consider it separately. No, this order will have to go. This is a wrong order. This has nothing to do with your case. No, that I'll consider. That has nothing to do with this order. That I'll consider. That we'll consider separately. That we'll consider separately. This order has to go. This is a mistake. I don't know how this order has come. Did you read the order? Did you read the order? Does it have anything to do with your case? Does this have anything? No, please understand. Please understand. Please understand this has nothing to do with your case. This order has to go. No, that we'll consider separately. Next week I'll have it. This order will have to go. This has nothing to do with this order which referred to is outsourcing. It has nothing to do with your case. Your case is after. Did you read this order? Did you read this order? Now, is it applicable to your case? And then that's all. That is the only thing that is given here. Now read the order. No, read the order. Now we'll recall that order and we'll keep it open for fresh consideration. Because there appears to be some. So his request for interim prayer will consider it separately. Perusal of the pleadings. One case made out by the petitioner. Would reveal that the order. No, otherwise it may have to go before the same judge to recall that order. Now, rightly or wrongly, no, just one. All right. Now, the question of vacating also won't arise, but this is because this is a wrong order. As you say, this outsourcing, I don't know how it has come. So, we'll ask the registry to immediately list it before the same judge. Immediately, I'll make some observation so that let it be listed and then let it come back. It is on going through the pleadings and on hearing counsel for the respondent. It appears that there is that the order passed referring to proceedings in WP 8664 of 2022 appears to be on oversight prima facie. But accordingly, office is to list the matter insofar as it considers, insofar as IA 1 of but how? No, correct. But that order and this, it has nothing to do with this.
That is also there, but charges vacated because now what happened, my lord? The petitioner has given letter to chairman saying that if you do not implement the order, then I will. The letter is also there.
No, nothing will, and nothing will happen. I'll ask the office to immediately to have it listed. Again, but you know. Now list this matter before the same bench which passed the order 22/4/2022 forthwith for necessary clarification.
Petition number 9016/2022. The legal counsel engaged in this matter pointed out about the inadvertent error which is recording the order.
Now, how many petitioners? How many petitioners are there?
There are 4 petitioners are there.
So out of these 4 petitioners, earlier interim order was granted as regards petitioner number
1. The earlier order was respect of subject matter, whether the petitioner can continue as a principal. The order was passed by the Lordship on 24/6/2022. Thereafter, my lord, continued the interim order yesterday, but inadvertently the order was only limited to the service of the first petition. Whereas, my lord, all the petitioners are entitled to continue in service.
This is from 62 to 65, is it? 62 to 65.
Yes,
And technically, it's covered by the division bench order.
my lord, there is a distinction that the senior council will address the substantial question of law.
And we'll have it on the same day. We'll have it on, when is that? Tuesday. Huh? No, but that is 60 to 62. Those matters, isn't it? On that day.
My lord, the factum matrix of the decision of the Honorable Division Bench was different as the ICR regulations and also the US Act were applicable. In the present petition, those are not applicable, my lord. So
That's
this
it.
distinction.
No, that we'll see. Prima facie, there's no case. Anyhow, only till the next date I'll extend.
My lord, and also the Honorable Court may be pleased to permit me take out hand delivery because of the urgency in this case.
So it is covered by the division bench. Why do you say writ appeal is not applicable?
Pardon, my lord.
Why do you say the writ appeal order is not applicable?
My lord, the prayer was on the footing that central regulations are applicable and also Article 246.
All that has been considered, isn't it?
Yes, my lord. But when the decision of the learned single judge, which was challenged in the writ appeal, was placed before the Honorable Bench, the learned single judge could not make consideration of the decision of the Honorable Labor State Court in Jacob Pudipara. And also Act 15 of 2019 was not taken into consideration. Whereas in these present petitions, my lord, these contentions are raised on the principle of parity, as laid down by the Honorable Labor Court in Araswani and Jacob Pudipara. Similar reliefs are to be extended.
No, we'll have it on Tuesday. Interim order directing the respondents not to be relieved, directing the respondents to petitioners 2 to 4 not to be relieved till the next date. Prima facie, we find that the law on the point is covered by the order of the division bench in WA 100198 of 2022. List the matters on Tuesday. There's nothing. We can't now reopen the writ appeal in these proceedings.
Council will assist you, Lord.
Let us.
Lord, can you put me take out hand delivery?
Yes. Made clear that the interim order passed cannot be made use of as a precedent in other matters. Yes.
I seek for 2 weeks' time to get information, subsequent developments in the matter.
List after 2 weeks at request of the petitioner.
Yes, ma'am. Much obliged.
So who is answering respondent?
The government petition has to be settled.
Correct. Just one minute. Now, this is a aided institution. So the papers must come from that. So let just ensure that somebody represents the institution.
Issue is what the employees of aided institution. But the government will take the responsibility and
No, they must send the papers to the government. You get, let them also get somebody from them.
Suitably call on the aided institution, not they are under the department. They can not say that they are okay before the court.
You take a, no, we'll fix a date. You take out hand summons, I'll pass an order. And then we'll ask them also orally to ask them to.
In addition to that, if there is a direction.
I will ask them. No, I'll ask them. I'll ask the petitioners to take out notice. Take out notice by way of hand summons. So you will send it to somebody. It says at Belgavi. It says
4 and 5.
Huh?
This one 4 and 5.
Emergent notice to respondent 4 and 5. Petitioners also permitted to take out notice by hand summons as well as electronic mode. It is made clear that if respondent number 4 and 5 do not make arrangements to appear, their presence may be obtained by passing necessary orders, including passing out bailable warrant. We send it to him, the certified copy. List the matter on 13th. Meanwhile, you just see telephonically, you can ask your education officer to. Now, we must not pass orders in the absence of the institution. It will create other complications. There will not be compliance. It will be difficult for them. Yes. 13th, yes.
But the improved order will not be.
No, who appears for the respondent? It says Wakalat not filed. Huh?
They filed their objection to Malaria associates.
No, there is there. VC. It's a SC2. We'll pass over. If he's there, you call him. Pass over.
The matter pertains to regularization, not the petition of the lordship not are working as RD doctors on permanent. Annexure K Mallots is into page 161.
2021 matter, madam. 2021 matter. Okay, file your objection within 2 weeks. Finally, that request made on behalf of respondent R1. Now, who is the answering respondent?
Answering respondent Mallots would be the state government because it is they Mallots who have to regularize their services. These scheme Mallots, the project Mallots is sponsored by the central government. But central government Mallots has in fact Mallots directed the state government not to continue this ad hoc process Mallots and to regularize their process. The state government Mallots, they have come up with rules also with regard to regularization. The definition of doctors Mallots under the regularization rules would include these doctors also. Mallots, each petitioner before your lordship Mallots, the first petitioner Mallots has put in more than 20 years of service. All other petitioners Mallots have put in more than 15 years of service.
Now the improved endorsement minutes, they rely upon the judgment minutes rated in Umadevi's case and say that minutes the request minutes for regularization cannot be considered. But subsequent to Umadevi's judgment minutes, in several other judgment minutes, the said judgment has been interpreted. The latest judgment minutes being the case of Chandramohan Negi minutes was the state of Himachal Pradesh, where minutes it has been specifically said that even minutes when appointing a doctor on contract basis, if there were to be a condition minutes upon the contract doctor, on the contract worker minutes not to seek regularization, even then minutes the regularization has occurred on account of the fact that minutes they have been working minutes for more than 15 years. But
now you fulfill all those criteria.
Yes, my lord. But appointment minutes as a contract doctor minutes was under a notification. Eligibility criteria was set. Applications were called for. Applications minutes was scrutinized.
So as on the date of 2006,
yes,
they have worked for 10 years.
2006 minutes, no, not 2006 minutes. First of the appointment of first petitioner minutes is minutes on 2002. As on to date minutes, if your lordship were to consider minutes, the service minutes that has been put up by the petitioners as on date, the first petitioner minutes has been putting more than 20 years of service. The other petitioners minutes are putting more than 15 years of service. But irrespective of the fact that minutes they have not completed minutes 10 years of service, the judgment minutes that are rendered subsequent to minutes Umadevi's judgment, but even there, the embargo of 2006 minutes is considered, and court has said that minutes, if minutes they have put in long service minutes, they cannot minutes be denied the benefit of regularization.
Let us see. Now you file your objections. Objections to be filed by the respondent as well as the state within 2 weeks. List the matter. After 2 weeks, interim order earlier granted is extended till the next day. You make a compilation of the judgments which and give it to the court officer. I'll also do.
Appear for respondents, my lord. Kindly pray for some time to file the objections, my lord. A statement.
Because for directing not to pay EL. My lord, I had approached this court, my lord, for a writ of mandamus. Earlier, my lord, there was the second round of litigation. But I'm a retired employee of Interim. My lord, just turned page number 35. The orders of this court, my lord, stated 14 September 2021. Page number 35, paragraph number 6. I mean, it is not in dispute that the petitioners were working in respondent number 1. They retired on attaining the they were entitled for the benefit of leave and encashment rules of respondent number 1 provides for procedure for payment of leave and encashment. Respondent number 1 was under a legal obligation to consider the request for sanction of encashment of leave benefit to the petitioners on the leave and encashment rules of respondent number 1. Respondent number 1 HMP has failed to perform its leave. Petitioners are entitled for admissible encashment of leave benefit on the leave and encashment. Petitioners have established their right for receiving encashment of leave benefit. And further, they have established that HMT has failed to perform its duty. Petitioners are entitled for a writ of mandamus. Not this court, lords, though it has not spelled out in as many words, has virtually recognized my right to the leave encashment. And my lords, they are only, and after that, my lords, in all fairness, they have considered my representation. But the representation, my lords, they come forward and say, look, we can't pay you because we are in a financial crunch. We will pay you according to seniors. Annexure A, my lords, is that the response to the orders of this court. Annexure A, my lords will find on page number 13. Page number 14, my lord, is where the reasoning starts. Payment of EL encashment will be payable depending on the availability of funds on basis of seniority.
The reading. Page
number 14, my lord, the first line.
Yes.
First paragraph. The payment of EL encashment will be
so they will give it to you. They want some time.
Time may be fixed, my lords. An outer limit may be fixed for payment of encashment of EL. I will take that order.
Now you just find out. Just find out, and how much time you require. You find out and make submission, or you can give them HMT watches.
My lord, let me place my statement, my lord. I'll file it, my lord.
No, correct. No, we'll give you time.
Yes,
But
ma'am.
as per annexure E,
Yeah,
we
ma'am.
only said that we need some time because of financial crisis.
Yes, ma'am.
So
That's
you get instruction, and then we'll work out some arrangement and give you time.
obliged.
And then we can close.
Obliged, ma'am.
The amount is not much, even otherwise, some whatever it is, you find out. So we'll have it week after.
Now, my lord, what has happened in this case is, in seniority basis, they are gone paying, my lord. That's the thing, it has got delayed. Seniority first year, ಅವ್ರಿಗೆ first payment ಮಾಡ್ತಾರೆ. ಅದರಿಂದ it is getting delayed.
So at least that list, you place it before the court so that they'll know where they're standing in that list of payment.
Yes, obliged, ma'am.
List the matter in the orders list on 20th. By then you find out. Along with the WP numbers
2386 of 2022.
2386
Of 2022.
yes,
3861 of 2022.
3861 of 2022
and 2926 of 2020.
2926 of 2020.
The last two notice has not yet been ordered. But if you take notice, I will serve a copy in advance, not that notice has been ordered now. Serve a copy in advance. In 3861 and 29. In 23861, in fact, they filed objections.
List along with signs. Yes. But now HMT is still function. Only one of the division is closed, or what is the?
One of the division is closed, man. This division is closed. Just other things is going on. It's working. Just I'll place.
Some of the divisions are running in profit also. The parent company may not no longer running in profit. Probably this division is the parent company may not, of which division forms a subsidiary. That not is not running in loss any longer. Not that stance that they're taking, financial hardship is there, not be completely countenanced.
Let us see. Yes.
Page 296.
Who is answering respondent, state or?
Now, serial number 28, we are appearing for respondent. Number 2 to 4.
Yes.
My lord, in the last date of hearing, my lordship directed, we requested lordship to give a week's time, my lord. Then my lordship granted us week's time to file objections for the amendment petition, my lord. But we have sent it, we have not received the amendment statement of objection from the company, my lord. Can we have it next week, my lord? We will file our objection.
Let us see what it is. Then I'll accommodate.
Please. Page 296 include order. Page 296 at annexure AG. This is the order passed by the appellate authority of the KSDL. This is on order 13/1/2023. After several orders of remand, the lordship will find that the relevant portion in that order at page 301. At item number 8.
Yes.
The board in its 254th meeting held on 7/9/2021 held at item number 5 above. Consider the recommendation made by the subcommittee in the background of the factual matrix of the case. The extract of the proceedings of the said meeting is reproduced below. The board took a note of the minutes of the first and second meeting of the subcommittee that were held on 15/7/21 and 29/7/21 respectively, and accordingly the minutes of the same were circulated to all the committee members. The same is confirmed by the board. Further, the recommendation made by the subcommittee meeting in the case of Dr. T. Venkateshaya was placed before the board for its perusal and approval. Accordingly, the board considered the recommendation made by the subcommittee meeting and accorded its approval for this is the punishment imposed.
to modify the punishment of compulsory retirement instead of dismissal from service with effect from 25/3/2019. The dismissal order, my lord, was modified into a compulsory retirement. This is the second one, your lordship. To withdraw the criminal case filed before the additional chief matrimonial magistrate at Bangalore, PCR number so and so by the company. Number 3, a fine of rupees 18,89,879, which was erroneously calculated in the miskin report, be withdrawn. But the third item is the serious allegation made. A charge sheet was filed. My lord, this was subsequently made after remand by this honorable court to the appellate authority for reconsideration. They have arrived at a conclusion, it's a miscalculation. The charge has been virtually, my lord, withdrawn. That is on, my lord, 13/1/2021. Thereafter, my lord, we sought for reinstatement because he has retired recently. The month of April. Therefore, my lord, the amended petition was filed. The lordship had kindly seen this order was came to be passed after the lordship got it, my lord, the amended petition was filed on 24th May.
Now, pursuant to the board meeting, they were required to modify as compulsory retirement to withdraw criminal case and to withdraw the fine. So then in effect, you were compulsory retired, which you have challenged.
Challenge. At the time of challenge, my lord, I got, my lord, the few days, that is, my lord, 2 months were left out for, my lord, for superannuation. Somehow, my lord, subsequently another order came to be passed. After passing this final order, that is, I have enclosed along with the amended petition, your lordship kindly arose. I filed along with the, my lord, yes, on 24th May 2022.
Pay for amendment.
Pay for amendment. That your lordship will find. Subject number 18.
Page,
my lord.
38. 38.
38. 38. That was allowed. After passing, my lord, the impugned order, just now read to your lordship, my lord. This proceedings was issued subject number 18. But after my lord, referring the issue, the lordship may kindly go to my lord, page number 39. Page number 30, next page. In view of the opinion, lordship got it. In view of the opinion of the advocate as stated above, the board of directors decided to modify the decision taken in subject number 6, decision number 2 of the 244 meeting held on 7/9/2021. Further, it was decided not to withdraw the case filed before the additional chief matrimonial magistrate at Bangalore Source. What was, my lord, taken a decision? The appellate order was to withdraw the cases filed against the petitioner. Subsequently, after passing the, my lord, the final order, one more proceedings was, my lord, taken up. For this, my lord, they want to file objection. It is, my lord, immaterial because they have already filed statement of objection to the main petition. It's a subsequent event at the instance of that. My respectful submission, my lord, once the charges are withdrawn, that has not been proved.
Charges are not withdrawn, my lord. I'm sorry, my lord. Let them prove.
Post of a director. Now, in view of, my lord, his retirement, my lord, the notional fixation and, my lord, the other benefits accrued to him has to be paid. Just to get over, my lord, the reinstatement, this order came to be passed after passing the final order. They have achieved their object by doing this, my lord, an order was passed subsequently.
But even otherwise, managing director may to take a call in this regard. So he may also decide to drop it.
My lord, that now the allegation what they are making that subsequently to only to avoid the payment what we have to give to him, we are passed this order. For that we have to file our objections, my lord, stating that why this order was passed, for what reason. My lord, the managing director has the power. My lord, in the previous meeting also they have given to the managing director the power to take decision on the board meeting. That three issues what they have stated here. That is, one is for modification of the punishment and withdrawal of criminal case and the fine. With regard to the second one, my lord, with regard to the withdrawal of the criminal case, my lord, it was decided in this meeting not to withdraw the criminal case. We will substantiate, my lord, before the lordship by filing our objections to that, my lord, the allegation what they are making. For that, only a week's time, my lord. Next week we are ready, my lord. With regard to the objections, also we will serve to them and we'll be ready. My lord, we have filed our objections, preliminary objections, my lord, on the main.
Get over the earlier final order of appellate authority. The MD cannot, my lord, add as an appellate authority. Appellate authority is the board. The board has taken a decision that the charges have not been proved. The managing director, just to harass the petitioner, my lord, the subsequent order came to pass that we will not withdraw the criminal charges filed against him. Insofar as, my lord, the charges framed against the petitioner, that is a misappropriation of 18 lakhs, was withdrawn, that is erroneously calculated. What remains, my lord, thereafter? The criminal charges framed against him was also pursuant to the allegation that he had misappropriated 18 lakhs. The appellate authority arrived at a conclusion that there is no, my lord, the misappropriations are wrongly calculated by the authority. Then what remains, my lord? I have to seek, my lord, the relief at the hands of your lordship.
Then we'll hear the matter. We'll have it on 7th. You file whatever you want. By 7th. Then we'll fix it, but it will take some time. So we'll see what time is available and fix the time and take the matter. But we have to hear the matter.
It has to be heard, my lord.
We have to hear it. Let us.
It has to be
we'll
heard.
Have it on 7th. No, that will see.
Kindly on 8th, my lord. 8th, my lord.
We will fix a date.
Please,
correct. But if we find that there is any malifieds, then
please,
we will
my
impose
lord.
exemption.
Please, my lord, please.
Now, so you examine it. We are not.
Please,
we will not come into way of any genuine action.
Please,
But it must be bona fide.
my lord, we will bring to the notice of the lordship, my lord, with regard to the decision taken by the management, my lord. First, it was taken by the board, my lord. It has given power to the management, managing director. Based on that only, he has passed these orders. My lord, simply just like that, he cannot withdraw the. My lord, he cannot just withdraw the criminal case which is filed, my lord.
No, you take your stand. Whatever it is, you take your stand. You will see.
Please,
we'll have it on 8th.
Please,
8th. Let us see.
Please,
He doesn't want on 7th. On 8th, we have division bench. We'll have it. List the matter.
Criminal matters, sir. There are plenty for your lordship.
Let us see. But if it requires some hearing, list the matter on.
Charges have been totally, my lord, taken away. They have withdrawn.
My lord, charges are not withdrawn, my lord. We will substantiate before the court, my lord, with regard to that. They are making allegation on the management, my lord. It is clearly held that only 3, with regard to the 3 points, my lord.
My lord. Person, my lord, with great respect. A person from a people's class of society was, my lord, unnecessarily harassed by this top management. But I should not make such a supposition, but ultimately, but this is the, my lord, even after withdrawal of the charges framed against him,
my lord,
and the appellate authority made a conclusion saying that the charges have not been proved. Again, managing director issued another order, but he is not an appellate authority, the original authority.
We'll have a look also at the content of the PCR. and see whether in light of the withdrawal of the charges, there is no case to pursue. We'll have a look at it. Yes.
Please.
Selection of post of library supervisor. Selection of the fourth respondent. Of the selection committee is a
No, all the rest are not represented. Who is answering? Who is answering? Who is answering respondent?
The deputy secretary and member Gram Panchayat library supervisor. Selection committee chairman.
No, so we have to. So somebody must represent them.
Committee is headed by the chief executive officer.
Just look at the respondents.
And the member secretary is the chief library officer, who is also a government officer under the state government.
The chief executive officer and chairman, Gram Panchayat library supervisor. There's no standing council for Jilla Parishad Chamarajnagar? Chamarajnagar. Then you take out notice on him. We'll have it next week. Let him come. Somebody, otherwise, you're sure he's there. Third Council Shri DJ Somayaji directed to accept notice for respondents 1 to 3. They list the matter on 20th. By then you serve, let him get instruction.
But I am at the nomination letter, my lordship. Today I filed a memo public.
Office to show the name of learned counsel so and so. T. Baswaraj. D. Baswaraj. And to delete the name of the learned counsel Abhinay YT, shown as representing the respondent. Now you get ready.
Yes, my lordship. My lordship, to keep under suspension, my lordship, similar identical case.
You file vacating stay. We'll consider it and pass order.
My lordship.
We can't orally do that. You file vacating stay. I'll consider it.
At least you petitioner do not participate.
I am not present. Till date, I have not filed a representation. 2 days back, I have written one letter that Mr. Abhinay Vaidhi is not appearing. So I am providing the copy of the petition. I have submitted letter to the respondent number 2.
Yes.
I have not sought for any relief from the department.
Thank you, sir.
Request of the council for the respondent. This is the matter week after next. You file that vacating stay, whatever. Interim order earlier granted is extended till the next day.
I'm looking for a short accommodation and I think but that's a final argument for the honorable matter is looking for re-employment as per the Bangalore University statute. The honorable court was pleased to pass an interim order on 28/4/22 to continue the services of the petitioner.
When did he retire now? Huh?
Not yet retired, my lord. Strength of the interim order is continuing.
Correct. So when was the in normal course he retired on? This is
34/2022.
13/4.
34. 20 April.
So till the end of the academic year, who appears for the university? You appear for the university. So there is some clause in the statute which says till the end of the academic year he can continue. So you find out now till then, and then we can close the matter. If you say, they say till the end of that 62 to 65, etc., we are not going to consider. Writ appeal order is there. Despite whatever argument they have one whole bunch of arguments they have. But that is a concluded matter. But till the end of the academic year, you take a stand, we'll record that and close the matter. When you want it. Yeah. List the matter on 20th. Interim order earlier granted is extended till the next date. Office to show the name of learned counsel Sri Suyog. Instead of learned counsel Arun Sham as representing RE. Writ appeal is covered now. We can't reopen that. It will become a mess then. You take it up. If the writ appeal is challenged, that's a different matter.
On this 26th.
No passover there.
Seeking promotion from the post of tax inspector to revenue inspector. He did not consider his since he got passed the appointment. But now with the case he has approached the state government, even in it does not apply. Paper 1 and paper 2 is not applicable. And it is applicable only for headmasters. Even the representation expressing the but Annex C has been given to special commissioner. That is not included in special commissioner as part. Annex C1 is given to respondent number.
C1. C1.
Right of the clarification issue.
Clarification is there. Just read C1 and E.
Page 98.
Yes. The same thing is as C1. Just read C, let us. Yes. C1 is the same. Yes.
ಒರಿಜಿನಲ್ ಕಡ್ಡಾಯ ವಸೂಲಿಗಾರರ ಬಗ್ಗೆ ದಿನಾಂಕ 15/5/2004 ಸೇರಿಸಿ ದಿನಾಂಕ 16/1/2007 ಸೇರಿಸಲಾಗಿದೆ. ಇದುವರೆಗೆ ನಾನು ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಪತ್ರದ ಮೂಲಕ ಕೋರಿದ್ದೇನೆ. ದಿನಾಂಕ 3/3/2022 ಆರ್ಡರ್ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಿಶೇಷ ರಾಜ್ಯ ಭಾಗ 4A ಆದರೆ ನನ್ನ ಹೆಸರು ಕಡ್ಡಾಯ ಕರ್ನಾಟಕ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಸರ್ಕಾರ
No, so there are two things. One is that General Law 2, and the second is Revenue Higher Departmental exam, isn't it? So what does annexure E say? Yes. 107. So for his post, general law is not required. Revenue inspector. I will only say that you will consider the petitioner. Petitioner. Correct. So I am allowing here. We have only sought for writ of mandamus. So I am directing them to consider C1 and pass orders. Huh? To consider C1. Now you hear it. If there's anything else, afterwards you can come and submit. I will dictate the order and keep it. If there's anything else, you can ask him to come and submit on Monday or Tuesday. Huh? Who is running? Let us see. The petitioner. So will start. Let him come. We'll start. Petitioner has sought for issuance of writ of mandamus and appropriate direction to respondent number 2 to follow the direction issued by respondent number 1 dated 11/1/2022 at annexure E and to thereafter consider representation dated 18/12/2021 given to respondent number 2 and 3 and consequently to promote the petitioner to the next higher cadre of revenue inspector with effect from 29/11/2021. It is the case of the petitioner. That the petitioner had made representation to respondent 2 and 3 to promote him to the post of revenue inspector. As per annexure C and C1. It further submitted that the insistence on clearing the general law papers 1 and 2 for the purpose of considering his case for promotion are only as regards are applicable only as regards the post of headmaster or headmistress of the high schools, as is evident from annexure E. Next, it is further submitted that as per the cadre and recruitment rules, only requirement as regards the post of revenue inspector is that he has to clear the municipal and local boards examination from a revenue higher exam, from a accounts higher exam and general law. It is further asserted that the petitioner has cleared the said subjects as required by the cadre and recruitment rules. Despite which it is submitted that no action is taken to consider the case of the petitioner. Land counsel for the respondent appearing for the respondent submits the representation that annexure C1 would be considered by the third respondent, bearing in mind annexure E as per law. Bearing in mind annexure E as per law. Accordingly, the petition is disposed of. Respondent number 3 to consider annexure C1 in terms of annexure C1 while noting the contents of annexure E appropriately as is permissible under law. I'll keep it without signing. You ask him to make his submission. Third response. Third response. All contentions and merits are kept.
Pertains to lots asking to advance increment on acquisition of PhD.
Correct. Otherwise, it will abate, isn't it? So we'll say no. Correct. It will dispose it off as abated. After you get it, then you seek for it. Correct. It's 2010 matter. So we'll say if it had abated, then you move the matter after filing application. Should they put it?
More the date of death, other than can take it.
The court has recorded in its order sheet on 24/5/2022 that the respondent submission that petitioners died on 10/5/2018. Accordingly, proceedings stand abated. Then you move the matter. Move. Needless to state that petitioner would be at liberty to seek for setting aside of abatement.
Operator in the audience. He was appointed on 3/1/2006. And was duly qualified. He collected post and order. He should have been appointed. The government has to elect a team.
Who is the contesting respondent?
He has been appointed. Instead of he, there are only two appointments. He was the first candidate.
No, but who's the employer? Zilla Panchayat, is it?
The appointment was made by the second respondent. That is the very document.
Yes. Nagarajappa was here. Nagarajappa.
Election is the government notification. They themselves say, and they say now one place 70. In place 70. Their first Rama Panchayat is Labhyavagu after 2 third paragraph. Labhyavagu Karavasu Kali Panchayat is the parliament, Pamu Kali. ಸತತವಾಗಿ 5 ವರ್ಷಗಳ ಸೇವೆ ಮಾಡಿಕೊಳ್ಳಬೇಕು. ಹೆಚ್ಚಿನ ವಿದ್ಯಾಭ್ಯಾಸ ನಿರ್ಣಯದ ಮುಖಾಂತರ ಖಾಲಿ ಉದ್ಯೋಗಗಳು ಈ ರೀತಿ ನೇಮಕಾತಿ ಮಾಡುವ ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಇವನು ನೆಕ್ಸ್ಟ್ ಪೇನ್ ಮೇಲೆ ಟಾಪ್ ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳಲ್ಲಿ ಸತತವಾಗಿ 5 ವರ್ಷಗಳ ಸೇವೆ ಸಲ್ಲಿಸಿರುವ ಎಸ್ಎಸ್ಎಲ್ಸಿ ಉದ್ಯೋಗಿಗಳು ಪ್ರಥಮ I was backward. I belong to backward category. I had worked for more than 5 years
We called for appointment. Kindly see, my lord, they will not agree.
We'll just send word. Let him come. Let Nagarajappa come. We'll send word. Let us. Or we can have it on Tuesday. Somebody from the other side, if they come, we can take it up. We'll have it on Tuesday. Relist the matter on Tuesday. Yes, Srinivas, we dictated that order. We said that no, that's okay. We have said writ of mandamus to consider annexure C1 in light of annexure E. He has undertaken that we'll consider annexure C1 in light of annexure E.
That is the relief. That's what I. That is the main relief. What I thought.
Then we'll have Mr. Bhatt will have it on Tuesday. Tuesday we'll have it.
Much obliged. Number 40.
Yeah, my lord. Serial number 40, my lord.
Yes.
I can drop the petitioner, my lord. My lord, this requires hearing, my lord. It will take at least about an hour, my lord. My lordship may kindly have it on Monday, my lord.
We'll have it on 13th.
As convenient. As convenient to your lordship.
Relist the matter on 13th.
Please, ma'am. Public.
Right now.
Yes, any other matter? ಅವ್ರನ್ನು ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ ಅಷ್ಟೇ. You ask him and then to inform the court office. You ask him within whatever time. You ask him and then they say, then we'll know. Yes. The order earlier granted is extended till the next day.
Thank you, sir.
ಇದೇನ್ ಸರ್ ಇದು ನೋಡ್ದ ನಿಮ್ದ
ನನಗೆ ಅಯ್ಯೋ
ಕೊಡ್ಬಂದ್ರೆ ಸರ್ ನಿಮ್ದೆಲ್ಲ ಅಕೌಂಟ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡ್ತೀನಿ ಸರ್ ಬಿಸಾಕ್ಬಿಡ್ಲ ಇದು ಲೀಕ್ ಆಗ್ತದೆ
ಬಿಸಾಕ್ಬಿಡ್ಲಿಕ್ಕಾಗಲ್ಲ ಕೊಟ್ಬಿಡೋರ್ಗೆ ಜಮೀನು
ಸರ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಬಂದಾಗ ಏನಾಗಿದೆ